Gwilym, we're in a pub, mate. Can you believe it? We're in a pub in London.
Oh, it's awesome. Very excited. And what a pub.
I know, Ye Old Mitre, something like that.
Ye
Old Mitre. Which you can miss, can't you, if you're walking down Hatton Garden?
London's most hidden pub.
It is it? Yeah.
There's a lamppost outside with the mitre on it. That's the only way to find it, basically.
So if there wasn't a sign saying London's most hidden pub,
it's a really big sign saying London's most hidden pub, ironically, which makes no sense.
Sorry about that. I stopped to have a sip of beer. Is that allowed? It's my first one. We're doing 3 of these today. This is our first one.
Yeah, we're getting each other's pheromones.
Yeah.
Don't get those on Zoom.
Okay, so can you smell pheromones?
I smell yours.
I'm sure we're going to end up editing some of this stuff out, aren't we?
Lee Davis and Gwilym Roberts are the 2 IPs in a pod, and you are listening to a podcast on intellectual property, brought to you by the Chartered Institute of Patent Attorneys.
How are you keeping? You're right. I've not seen you since the last time we were in a pub last week.
Very well, thank you. I've never been to a pub before.
Have you not?
No.
It was a cafe kind of thing.
Very well, thank you. I was actually looking up the history of this pub.
Oh, okay.
It's really interesting. I looked up mitre and then myths, and it said it's a myth that the mitre's haunted, and it's actually a different mitre as well. So there's a mitre somewhere else named like this pub that doesn't. That
is
ghosts.
Haunted.
No, that isn't haunted.
Oh, that isn't haunted.
Isn't haunted either.
Right. Okay. So this isn't the mitre that isn't haunted.
Correct.
Yeah. Got it.
But this is also not haunted.
But does this one claim to be haunted?
No, it's got some other stuff. The Queen danced around a tree.
Wouldn't it be amazing if, having not claimed to be haunted, this was haunted?
There you go. Well, if the podcast dies today, we could be the ghost.
We could leave the mics on quite late tonight, couldn't we? And see if it picks up any supernatural occurrences or just drunk patent attorneys.
I actually read the report about the mitre. They did try to find ghosts in.
This is just too exciting for words. Go on.
They all went into the cactus room and they formed a safety circle before they kicked it off. It's quite exciting.
You would have to be quite safety conscious in the cactus room, wouldn't you? Yes, because it's full of yeah. Should we crack on with the podcast? That's probably the best point to do that now, isn't it? So we've got friends of yours with us today, which is really exciting. Because very often I know our guests fleetingly, don't we? But we've actually got real people in the room with us who you know very well.
My 2 best friends from school.
Your 2 best mates from school?
Yep.
Have they known you that long?
Yeah.
About 10 years?
They're not my 2 best mates from school. They would have been if we'd been at school. Absolutely, we'd have been in a gang.
So we shouldn't keep this from the listeners any longer, should we? We've got Duncan Matthews and Noam Shemtov from QMUL. Have I got that right? QMUL?
That's right.
You don't just say QM, do you?
No, it has to. It's branded QMUL.
QMUL. Okay. Duncan, as soon as you started speaking first, do you want to tell us a little bit about yourself, who you are and what you're doing here? How did you find yourself in this room?
I found myself in the room quite easily. I've been to this pub a number of times, but it's the first time I've managed to get a seat, so that's quite an achievement in itself. And usually standing at the bar.
You've got a private room.
So I've been working at QMUL for 20 years now. I used to run the certificate in IP, which some of your listeners will know about. And I teach patent law, European, US, and international. So that's pretty much my role at Queen Mary.
20 years, that's quite a long gig, isn't it? That's yeah. It's not time to move on yet?
No, I mean, I used to work at another university before that. And because it was 20 years ago, if you wanted to look at a map, you got an A to Z. So I got a hold of an A to Z of London and looked up on the map to find out where QMUL was, because that's what I wanted to work. So having found it on the map and got a job, I'm not going to go anywhere else.
You're not going to go anywhere else. And also, you've not got a lot after Q on the A to Z to go to, have you? So,
no, pretty stuck, yeah.
Noam, how about you, sir? Introduce yourself.
Right. Not as long at QM as Duncan Matthews, so 12 years now.
That's still a fair gig.
It's a fair gig. Used to run the certificate as well after Duncan. Taught on the certificate for a certain period of time. So again, some of the listeners there may know me actually from the other side of the room. Did some trademark teaching at the time, and now at QM doing. So teaching IP in the creative industries and IP and the software sector. Also, for the last 3 years, being the deputy head of CCLS. We talked about branding before.
Yeah, you can't do the acronyms. You've got to give it to us in full.
Absolutely. So QM is a bit of a different one in the sense that the School of Law is actually it comprises comprises two completely separate branches. You have the Department of Law, which is not us, and the Center for Commercial Law Studies, that's CCLS. This is the branch that is responsible.
So that's the bit where IP sits.
Yeah, exactly.
Got it. Well, we always do a huge amount of pre-planning before our podcast, but knowing that Gwilym would have this in hand and he would have done all the planning, I'm just going to hand over to, because I don't know if it's not a conflict, is it? But you do a little bit of, it's not called teaching, is it? What you turn up to talk.
No, I've been talking. I've been teaching how to talk. I've been talking every year. I've been lecturing on how to draft a patent for a cheese grater.
Really?
For 20 plus years.
But you've been doing the same lecture for 20 years?
Yes.
Okay,
Twice a year.
And on one occasion, we lost the cheese grater, didn't we? And that was very, very difficult.
It was. I just had to mime it.
Yeah.
Miming a cheese grater, which was doable actually. I brought cheese in once. We actually grated
real cheese.
Yeah, but then
Very tasty.
you can't do that kind of thing these days. It's just health and safety. It's just not going to happen.
I know in the kind of post-COVID era, you can't grate cheese.
No, even before COVID, you couldn't grate cheese. Actually,
Why?
I don't know. Don't blame COVID for everything. God. Yeah. Okay. Well,
It's all yours, mate. All yours.
so we've had people from every kind of walk of life within IP on here, from inventors to judges to patent office people to searchers and loads of other things as well. We've had some academics before. We've had your colleague Gaetano came on talking mostly about More Than Just a Game. Very cool.
It's great.
Good conference that was as well. But actually, it occurred to me that we don't hear that much from the world of academia in IP. There's a lot of it around, isn't there? There's a lot of IP specialists, and we don't always cross over as a profession with the IP kind of academia world. And Duncan, you and I, we did do some planning. We just forgotten what the planning was. But you and I had a really good chat about this. And one of the points I think you were making very strongly was about actually where the role of academia fits in within the IP world and why it's so important. So over to you.
Yeah, well, I mean, there are three types of things that we do in our job. One is the sort of standard educational provision. So whether that's trainee patent attorneys joining the certificate program, whether it's our law students doing the LLM, or PhD students, that's the kind of conventional model of what people do when they work in universities, teaching and training these types of people. But the second thing that we do is has a very fancy title of executive training. That's what the university like to call it. We're actually doing sort of real life skills and providing people with the legal and professional skills they need if they're patent attorneys, solicitors, etc. And the third type of activity we do is sort of blue skies. And that's where I think Gwilym and you and I had a chat about this recently, because I feel very strongly that what we want people who work in universities to do sometimes is come up with crazy ideas and then have a debate about it. And unfortunately, most of the people who work in business don't have the time or the opportunity to do that. So that's part of our role, is actually saying, for example, I had a paper published recently saying, what if we raised the bar for the disclosure requirement for European patent applications? And we may or may not want that, but there are different arguments about whether that would benefit society at large, etc. So I think somebody should be asking those difficult questions, and that's why we pay our taxes and university fees, so that people are paid to ask difficult questions, even though it's not that they're coming up with the right answer. And my final point on that is that very, very good former student of mine who now works in-house for a life science company actually wrote to me, he DM'd me on LinkedIn and said, Duncan, will you stop asking difficult questions? Because it's just not helpful. We just want people to say that the patent system is good. And actually, I don't agree. I think we do want people to ask difficult questions, because the patent system has never been a static thing. We want it to change and improve. So that's my message for today.
Thank you. And I think when you train up, as most patent attorneys are, you just get taught it. You get taught it maybe at Queen Mary or the other kind of university courses. You get taught on the job. You learn through the exams and everything else. But you take ever such a lot for granted and assume that someone somewhere has made the rules, and those are the rules, and you just got to do what you can within those rules, which of course is kind of true, but you never think who made the rules and why did they make the rules and everything else. And people occasionally do ask these questions. There's a big substantive patent law conversation going on at the moment.
I was
about
going
all
to ask
kinds
that
of stuff.
one.
You do that then.
Can I ask that? Can I ask that
give me a
difficult
rest
question?
for a minute.
Can I ask that? So that, I mean, I'm not going to say where we are on it and why we're talking about it, because politically we're doing lots of stuff at the moment that we just can't talk about. Should the UK have a grace period?
What do you mean?
Right, chit chat.
Is that a difficult question you've ruminated?
It's something I teach because when I do a comparative course on European and US patent law, we discuss this a lot.
Let me chuck some context in there. So I won't go into the detail because I can't, because there's lots of stuff that we're doing at the moment that's sort of behind kind of parliamentarians' doors and stuff like that. But the UK's negotiating bilateral trade agreements, it's negotiating kind of multilateral trade agreements and so on. And grace is something that continually comes up in terms of whether our partners do and don't have them and whether the UK should or shouldn't have one. We are where we are largely because the UK is a member of the EPC. So that's an important consideration for us. So has there been any kind of academic thinking done around the grace period issue? We've done lots from sort of like the professional side of it, but it's, and if there isn't, would you do some?
Well, gladly. Well, I mean, certainly for the free trade agreement debate, we're aware of that on the academic side, and the debate about whether this would find the UK in contravention of the EPC, etc. So that's something which is there are arguments for or against whether that would be a contravention of the EPC, whether there would be kind of practical benefits for the users of the patent system. As I alluded to before, I think you can look at some examples from the United States where prior publication would be permitted, and whether that dissemination of information is beneficial to society as well as the inventor. I think you're right, Lee. I think we probably need a study on this.
Yeah, no, that's great, isn't it? So, and that's my job on this podcast. I am the kind of like the semi-literate IP person in the room, so I'm allowed to ask the questions that are a bit of curveballish.
That's a great question.
Back to you, mate.
That's a great question. Actually, so on the blue skies thing, there's a whole bunch of topics actually we've touched on over the podcasts.
Yeah. Do you know this is our 61st?
No.
Yes.
That's amazing. 39 to go to the big one, next pub. One of the other hot topics we keep coming to, and Noam, you touched on this already, is the AI side. Talk us through what you've been up to. What's the gossip in the world of AI and IP at the moment?
The good point from my personal perspective is that next year I'm on sabbatical with a view to write a book purely on AI. Well, particular angle of AI and IP. I'll keep it as is for now. And patent is gonna take going to be hopefully quite a big part of that book. I think that when it comes to AI and IP, there are two areas that are sometimes conflated. I mean, people talk about AI and IP in general, but one area that is often overlooked, and I think in practical terms is probably of more importance, it's less sexy, but it's more important, is the actual patentability of AI itself. Rather than, this is where there's a lot of action in the UK, at the EPO level, and elsewhere around the world, and probably because it's quite technical, not that futuristic, at least on first glance. People look at it to a lesser extent. I actually had, when was it? I think 3 days ago, an interview with the Financial Times that on AI and patents. There is a piece that should be coming out in about 10 days.
Oh, wow.
On that. So, world exclusive.
What did you say? What did you say?
We probably can't do that.
Spoiler.
There'd be some sort of breach of copyright, wouldn't there? Which we probably can't do.
Yeah.
But it looks like the Davos saga is coming to an end. It had a good run. There were some undulations, but it is coming to an end, and probably those of the list, those among the listeners who are interested in the area probably know or maybe familiar with my view that I first expressed 2018 in the report that I did for the EPO on that, and then also along the line in various conferences and talks. It is a bit much ado about nothing, at least for the foreseeable future. There there is very little need for any movement in terms of revision, where I think we need to probably, we may need to tweak the system, not tweak the system, sorry, but adjust some of the conceptions that we apply is in relation to inventive step. This is where examiners are compelled to take into account already here and now the existence of AI, and also there's a piece that I think published this January. It was up on SSRN on AI and inventive steps. So AI generated or assisted inventions and inventive steps. So on inventive step, going back to the original question, various tweaks that needs to be done and are being done or taking place. On inventorship, nothing is happening. I don't think that anything should happen, and it looks like the courts feel.
And do you think nothing should happen? We'll move on from AI in a minute.
No, I've got an AI question.
Okay, I'll do mine then.
Yeah.
So do you think that there should be no change on AI inventorship? Glad we're doing this one first.
Oh, and I've got the question that follows. This is excellent. It's almost like we've been thinking about it.
I'm glad we're doing this one first. Do you think that the reason that you don't need to change the rules on AI inventorship is because AI basically can't invent and won't be able to invent for a long time? Or is it because you think that AI shouldn't, even if it can invent, it shouldn't be allowed to be an inventor?
No, it's not the second one. And I think actually, I think it's very useful to separate between two sub-questions in this context. When you look at Davos is not about policy. Davos is about the statutory language of patent legislation around the world, and whether it's not about does it allow for it or not. Yeah. And people sometimes tend to conflate the two. Yeah. When you get into the policy question, if you ask whether the law need to be changed, the main argument is that if we don't change it, we might end up with inventor-less inventions that would stay outside the patent system. That does not appear to be the case. I mean, when you look, for example, in the US, when you look at what the proper industry, the heavyweights in the AI industry think. So you look, for example, at the request for comments from the USPTO, and you look at Ericsson, IBM, Alliance of Inventors, the people that actually do that as business. None of them, without exception, appears to think that you have inventions nowadays without a human inventor. And again, the 2018, that was my conclusion. When you look at the rules of inventorship, you capture a human at present at each and every instance, and therefore we don't need to change.
So I was probably thinking about AI too hard coming into this podcast. It was on the train this morning.
But it wasn't as hard as AI thinks about it.
Well, and that's where I'm going to go with the question. It's just like we're symbiotic.
It's like we've done 61 podcasts.
Yeah. So we had Ryan Abbott on, didn't we? And we didn't discuss what I'm going to discuss with him, and we should have. Yeah. We've had the folk from IBM on talking about AI. So we've had lots of people on talking about AI. You're the first one to get this question. No, I'm sorry, it's only because I didn't think about it before. So I was on the train this morning, reading about some AI and inventorship stuff. I don't know why I was, but it just struck me as something interesting to read on the phone. And I thought, so if AI is going to be as sort of evolutionary and reach the point of beyond human thinking, so let's kind of take us there. And if we do accept that AI can be an inventor, if AI is that critical and advanced in its thinking, doesn't obviousness disappear?
Absolutely. That's if you look at the Australian court. So the recent decision in April. So the full court, right? The full federal Australian court reversed Justice Beach's initial decision, so which was in favor of AI inventorship. And one of the points, just an obiter dicta, that they said, if and when this day comes, what does it mean for inventive step? Because how can you benchmark something which is carried out by a machine against the human in terms of obviousness? So I absolutely.
Did you like that?
It's very good.
It's almost like I've learned something in 10 years.
No. Well, there's a bit in, one of the, not selling Ryan Abbott's book, but actually it's quite a good book because it draws the parallels to some other things. And he talks about the test for negligence in driving. And if driverless cars become better at driving than humans, then you'll kind of almost have to prove why you weren't being negligent by driving the car rather than having it driven by because it's the care rises. It's the same kind of impact. Actually.
Do you know, we're saying some really profound things here, and it's quite stunning, isn't it, that when you've got an audience present, they're not clapping.
No, guys. Duncan's got the next profundity.
Yeah, well, I'm not sure that the Dabbers case is completely finished. I mean, let's see whether anything happens at the UK Supreme Court. And, of course, we're waiting for the EPO Enlarged Board of Appeal as well for its decision.
In the US, I think. Also, they applied for the Federal Circuit. Yeah, they applied.
So we're not quite done there. I was taking part in an EPO webinar a couple of weeks ago. So I will quote two more eminent people than myself.
What? There are two?
Two, yeah. One of them is Lord Justice Burse.
Okay,
fair enough.
Yeah. Sorry,
he was on the podcast.
And of course, at the beginning of his dissenting decision in the Dabbers Court of Appeal case, he said, actually, this is about patent prosecution procedure. It's about filling out the forms. Which I think that's an important point to keep in mind. And the other eminent person was one of the other panelists at the EPO, Professor Dan Burke from the United States.
We haven't had him.
We're getting him.
You had him as well, okay. And he said, actually, these are computer implemented inventions. That's pretty much all they are. So what's interesting about Noam's comment is that he's sort of talking about the next level, about obviousness and inventorship. So I think that is going to be the more important debate. And again, as Noam has already said, it's about splitting off what the patent system does at the moment, and who can be an inventor and who can derive ownership from an inventor. Then the separate issue about what do we want the patent system to look like in the future when our AI is developed further. And I agree, that's the more interesting discussion. So maybe you can invite us back next.
Yeah, no, definitely.
This is why you need the blue sky thinkers.
Yes,
because they're thinking again.
Interestingly, Duncan's point about Lord Justice Beers is, I think in the same sentence, he cautioned against, and I hope that I use the exact terminology, advocacy by glamour. He said, this case is about patent prosecution rather than, advocacy by glamour. When we make who is in favor of progress, who is in favor of advancement, it's not about that. It's just about patent prosecution. How do you fill the form, as you say? What the patent...
It's Form 7. Form 7. No, CEPA's actually put an amicus into the Supreme Court purely saying, can never think about the points Burse made, because procedurally we'd quite like to know what the situation is. Yeah. But it got complicated because there was a point about, well, can you not just put your cat down? So I don't actually have an answer to that. So.
Put your cat down?
As the inventor.
Oh.
If you can put AI down because you think it might have invented it, you must have put your cat down.
I thought you were euthanizing it.
Put the cat down. Oh, no.
Why would you do that?
Kill the cat. No.
This is why I'm the idiot in the room.
I'd just like to point out that I think it was in the first instance decision in the patent courts, there was a reference to whether a cat could be an inventor. So it's not a unrelated issue that you raised.
I hate cats. They should never be allowed to do anything ever.
I don't see why a cat couldn't invent. That's a different podcast. We need to get a cat person on. For that one. But Blue Skies is, again, this is exactly what the Blue Skies is about. It's thinking they're far, far, far beyond kind of Form 7 and thinking about what about the role of IP within society and everything. And I think I mentioned to you, Duncan, there's an ex-Queen Mary academic, I don't know where he is now, called Peter Dreyhus. And I remember very early on in my career attending some talk he gave where someone said, so obviously IP is out there to stimulate innovation. And he stopped them there. And normally you think, no, isn't that just an axiom? And he stopped them there and he says, no, that's if you view it through the capitalist prism. And I thought, oh my goodness me. There's other prisms. My prism isn't big enough. But it was actually a really good insight into just how far back you can go. And again, the role of blue sky thinking. And I was interested in how influential academia is when it comes to the policy discussions. When government gets into it and everything else. You guys, you're writing papers at the EPO, Noam, obviously.
Just a thought, so purely blue sky, but to an extent, if we look at the way the patent system works now, and I'm taking us back to this discussion, but this time on the inventive step side. So one of the things that you're looking at when you come to an invention-making process, when you look at an invention-making process that involves an AI a system, is one of the things that may differentiate your invention from the state of the art is the data that you hold. Right? Because in the end of the day, when you look at the state of the art, if the data, it's a proprietary data, it's yours. Now, if you think about that, that probably provides, to an extent, an incentive to keep data as a trade secret. Now, if you look at policy statements, for example, by the European Commission, how crucial for data to be open data in order to drive forward innovation, including in AI, you see a conflict. So policy-wise, where do we stand on that? Do we change the patent system in order to accommodate such policies, or do we just accept that that's a price that needs to be paid?
Are you guys being listened to? Do you find that your voice is taken account of?
It depends. I mean, I can give a good example of being listened to. Last year, I was leading a team of researchers, and we were asked by the World Health Organization to make a submission to World Health Organization Advisory Committee, which was looking at how do we govern the use of CRISPR human genome editing technologies. And that raises all sorts of questions in Europe about whether it's contrary to ordre public or morality to allow a vector and invention which involves altering the germline identity for generations in the future. And, we pointed out to the EPO that actually the way that that's been dealt with is actually quite helpful. But in the examining division in Munich is that they basically say you have to just amend the claims to exclude the things which would be contrary to ordre public and morality. So you can use the inventive concept for agriculture, etc., or for somatic use, but not for germline identity. So that's a good example, and that was adopted in the World Health Organization's final report. So that was quite nice. Being a bit more controversial, I think there have been cases with the UK government where they will ask you when they want the evidence to support something that they've already decided.
I don't think that's controversial. I think that's just the UK government. You can't claim that was controversial.
There's in the last couple of days, there's been it's been reported in Geneva that the UK has made some submissions about this so-called TRIPS waiver for dealing with COVID, allowing WTO countries to say that patents and related rights cannot be enforced for COVID-related health technologies, and the UK has been very strong in saying that those protections should remain. But I'm not sure who the UK consulted about that. So that's my controversial point for today.
No, we've had a few waiver discussions.
We have had a few, haven't we? Yeah.
I kind of hope we might get to the waiver actually, because I've noticed that the academic community is more, may I say, pro-waiver perhaps. There might be a massive generalisation, but it seems to be a little more pro-waiver than...
Certainly those we've spoken to on the podcast have been.
Yes, there you go, thank you. Than others. And that's not to say that the wrong points of view. I think again, sometimes that blue skies thinking gives you the bigger picture.
Again, this is more definitely lies within Duncan's sphere of expertise. I'm just, to an extent, as an outside looker, an observer, when you think about waiver, you talked about waiver. So if we want to be controversial, to me, just on the basis of the news pieces that I've been reading, one of the main struggles was not with necessarily the patent system itself, where you actually had licenses. It's with the underlying technology. And that's trade secrets, by and large. Now, what are you doing? I mean, are you going to introduce, or are you going to suggest a compulsory license, for example? That would be pushing it even further than a mere waiver. I mean, yeah.
And I'm treading on thin ice here because I know Duncan's a bit of a TRIPS expert, but I do know that one of the arguments, or the concerns raised, has been that there's a broader failure of TRIPS, which is nothing. Forget the waiver. The idea that you have kind of a global IP arrangement, part of it was to help developing countries, and it's felt perhaps, and I think it was Luke has expressed this, although not on our podcast. I don't know. The system has failed developing countries on TRIPS, and so maybe the argument isn't so much that we need a waiver because of what happened with COVID, but I can't believe I'm speaking for a waiver here. I don't think it's a good idea.
Yeah, get off this podcast.
No, I'm just open-minded. No, I'm not. I don't think a waiver is a good idea. But maybe there is a bigger picture thing that somewhere the IP system hasn't worked brilliantly for developing countries the way it was intended to through TRIPS. Is that
I mean, I can paraphrase Peter Drous and say only if you're looking at it from the Marxist perspective. I'm joking. Don't edit this out.
It's all about the prison. All about the prison.
So I'm going to give another plug to our favourite newspaper, the Financial Times, because last June, a professor at the University of Copenhagen, Timo Minsen, and I, we wrote an opinion for the FT in which we commented on the fact that academics in the UK and some in other English language speaking countries have been very much pro IP waiver during the pandemic. But there's another school of thought, particularly amongst the German IP academics, which is that actually you shouldn't do anything to undermine the patent system and jeopardize the innovation system. There are two schools of thought. And what Timo Minsen and I said in the FT was that actually, both those sides have their merits and their problems, both those arguments. But actually, the interesting thing is to say, well, what does this tell us about the way that the IP system fits within, it's just part of a toolkit. It's part of how we want to promote innovation and the public interest and benefit society. So it's just part of that. So we ended up saying, whether you're for and against IP waiver, what we want is to have pandemic preparedness for the next pandemic when it comes. We want to see local manufacturing hubs. We want to see stimulating innovation, etc. So we were typical academics, and we said, well, yeah, we can see the benefits of both sides, and we were sort of down the middle on that one. So that's my message.
That's the benefit of being an academic rather than advising a client.
Actually, this is can I unleash my thought of the weekend? I don't know when this hit me, actually. Over the weekend.
We're recording this on a Tuesday. Oh, your thought of the weekend.
No, not the weekend to come.
Not for the weekend to come.
Not for the thought for the weekend.
Sorry.
Little break. Thought for the weekend.
I thought it was only my barber who asked me those questions.
No, because I was actually reflecting on the axiom that IP is good for innovation. And thinking that there's all kinds of different kinds of innovations. So some of it's wonderful, like vaccines and kind of healthcare and things, and some of it isn't so wonderful. And actually, I wondered whether we just need to put one more word in there, actually, which is that IP should be used for sustainable innovation. How's that?
That is to an extent comes a little bit close to a PhD student when she axed it out of her thesis because it's not. She one of the ideas that she had, not because it was a bad idea, just because it didn't fit within the theme that she explored for the previous 2 years, was to look at the patent system in relation to the UN declaration. So there are 10 sustainability-related objectives. I don't know if it was the General Assembly or which of the UN agency that came up with that, but in relation to which there is broad consensus. And there is broad consensus because they're extremely general. It's like, who's in favor about the abolition of poverty? Who's in favor of, and so on. But at least as a starting point, trying to benchmark innovation, worthy innovation, although I personally think I'm in favor of the principle, I think it's a slippery slope.
Can I just check what you were saying? I've really enjoyed this podcast because you've been doing some quite kind of blue sky thinking stuff, which I love. Were you suggesting there that you should only be able to protect stuff in the future if it speaks to an agenda that is about sustainability? So everything else gets scratched. Is that what you were suggesting?
That might be a little bit tighter than I had in mind, but no, I just,
So it doesn't matter
in
what you
broad
suggest,
terms, there's good innovation and there's bad innovation.
Yeah.
Let's just have good innovation.
So you can't.
Finding that's a bit tricky.
So missiles would be out in your world.
Bad missiles.
Cheese graters?
Cheese graters.
You can really hurt yourself with a cheese grater.
And other people.
No. Absolutely.
But Noam's right. These UN MDGs, they're called. Another acronym for you. Millennium Development Goals. Very focused on sustainability. Not just for health and patents on healthcare technologies, but in sustainability of food and the environment, etc. So topic. Oh, can I just get another point in as well, which is I mentioned a minute ago that this whole debate about the role of the patent system is just part of the toolkit. An important other part of the toolkit, which relates to sustainability as well, is in relation to competition law. And that's something else that I've been working on a lot, about how the competition law system might impact on the way that the IP system works.
They don't like each other, do they? They're kind of opposites, aren't they?
No, they have. For example, they have a big debate about refusal to license. Is that contrary to competition law? Yeah. So that's another one to watch for the future, I think.
Oh, can I carry on?
You can carry on, but I'm just
No,
going
you
to
go,
say
you
that
go.
part of my job is like timekeeping, as you know, and we are kind of.
But these are my oldest friends.
I know, but there are still rules to the podcast.
Right. I had 2 questions. Which am I going to do?
No, do both. So do both.
Sure?
Yeah,
Okay.
Just as long as you know
Question
you're on the clock.
1. Isn't it odd? This is a rubbish question. I'll turn it into a proper question in a minute. Isn't it odd? It's an open-ended question. I'm going to make it better. Isn't it odd?
He's playing to an audience. For anyone who's just listening and doesn't have a clue what's going on, he's playing to his audience
Isn't
of
it-
3.
Isn't it odd that IP gets itself into ethical conundra quite so frequently? It seems such a strange place for these questions to start. Why is that?
It didn't used to be like this in the old days.
I know,
There's nothing worse than getting a load of blokes in a pub to talk about the old days.
Bubblegum that shaped like cigarettes, no one cared.
At the beginning of my academic career, I interviewed an executive of Volvo Cars. His name was Lars Annels, and he was the chair of the TRIPS Negotiating Council. When the WTO was being set up and they were drafting the TRIPS agreement, and those were his exact words. He said, it wasn't like that in the old days. We used to sit down, have a glass of brandy, and we'd come up with an article of the TRIPS agreement. And nobody objected to that. So it did become politicised in the mid-90s. So, Noam, over to you.
Yeah, it's actually, you have today quite a few academics who work, I wouldn't say exclusively, but mainly in the area of IP and human rights. And when you talk about human rights, I mean, this is, it's political almost by definition. Now, it's there whether we like it or not, and it's going to stay there. And you go down this road. What is a human right? Well, right to property is a human right, and from there, the road to IP is it's pretty straightforward.
My final comment on that is that I've written about this quite a bit, and what the UN has done is it's created sort of a hierarchy of fundamental, inalienable human rights that can't be taken away from somebody, like your right to life, your right to health. Yeah. And the fact that IP rights tend to be temporary, they can be revoked, they can be assigned. And the UN has said these fundamental rights are higher up in the hierarchy than an IP right, which is a temporary right, which can be taken away and which is granted by the state.
Which is very sensible.
Yeah.
So the right to patent is less important than the right to life.
Unbelievable, huh?
Who'd have thought it? Who'd have thought it?
Block the let's move this podcast completely
There is a whole
away from
podcast
IP.
there.
But the innovation system is essential in order to develop healthcare technologies, in order to enjoy the right to life.
No, that is
Oh, brilliant. Now that's the sort of manoeuvre I love.
back on track. And that was my second question. You've mentioned, we've talked about hot topics like AI, like waivers, and you mentioned one I hadn't even heard about, which is sustainable. I thought I'd made up at the weekend. Turns out the UN's got a mandate on it about innovation and sustainability. Any other sort of hot topics that you think kind of the academics perhaps are seeing before we are? One I'd mention immediately is the whole anti-IP lobby, for example. But is there anything kind of out there that perhaps we've not got an eye on?
It's been there, but I don't see them. Do you see them, Duncan, like growing in influence and in strength? The anti-IP lobby as a whole. So people which are against IP, rather than the IP system as it's stacked up today.
Can I say something else controversial?
Only if it is.
Some of the people who are anti-IP don't understand the IP system. I think that's the reality. So they're not.
Okay, they probably also don't listen to this podcast.
But they should. They should.
Not controversial, but in terms of importance or significance, I think that, and it's highly political. The whole front discussion and the way the different jurisdictions actually deal with that, because IP is international. You see, what was it? I think fairly recently. For example, U.S. courts, Chinese courts, UK courts racing with one another, and both in the front context and also I think beyond that, as in, I decided on this issue, and another court should not step in, and you have this jurisdictional race.
I've been working with an academic at Wuhan University on exactly this issue of FRAND, and
we are in the same room with Duncan, by the way, Wuhan. I want post-COVID.
What's interesting is the Chinese IP academics talk much more about the role of the public interest when they talk about FRAND disputes as well, and maybe that's kind of an underlying theme about a lot of the issues we've been discussing about human rights and sustainability and morality, everything. It's about how do you position the role of the public interest when you apply patent law principles. So that's probably another research project we should do now.
And compulsory license and in a front context, and especially when it's extra jurisdictional.
Things to watch out for.
So my job very often is to kind of bring us to a close, isn't it? So shall I try and get us to a natural close?
Do it.
Shall I do it? Shall I do it?
Do it.
It would be unforgivable of me not to mention, Duncan and Noam, that we in SEPA QMUL enjoy a kind of long relationship, and hopefully we both kind of give and take and get a huge amount out of that. We're incredibly thankful for the work that you've been doing, particularly around the UPC. I think I can say that as an acronym, kind of. Everyone knows what the UPC is on this podcast, don't they? If they don't, they can Google it. What's coming up on the UPC? What exciting things from QMUL have we got to look forward to in terms of UPC?
Well, Lee, I can throw in another acronym, EPLC.
Oh, EPLC, of course,
Patent Litigation Certificate. So on the 15th of June, the Administrative Committee of the UPC will start to accept applications for higher education institutions established in a member state of the EU who intend to offer an EPLC litigation training course to give European patent attorneys the right to have this extra certificate.
That's those who don't get in under grandfathering. So
exactly, those who didn't do the Nottingham or QM course, etc., before the 31st of January 2000.
That lovely date.
Yeah. And we're, as Queen Mary, we're applying to be accredited to provide this European patent litigation.
Because you're established in an EU member state?
We are established in France, and we've been there for 10 years. The French Ministry of Education have given us this status as a higher education institution established in France. So we have the European basis within an EU member state to be eligible to apply for the course. So watch this space, because with any luck, Queen Mary will be offering that litigation training course, particularly aimed at the UK patent attorney profession.
But open to everyone, I imagine.
Open to everyone, yes.
Thank you so much for that. And kind of just to reiterate, we really appreciate working with you guys on this, and that is just so important for the profession going forward. That's great we get a plug in at the end.
Oh, in Duncan's defence, he's been poking us on this for about 3 years.
I think my first dinner with the then SEPA president, Roger Burt, and Vicky Salmon from Litigation Committee was in March 2015.
I said 3. I meant 7.
You meant 7.
It's been a while, yeah.
And my last job is I always try and bring the podcast to an end with a kind of like a totally tangential question, which is nothing at all to do with anything we've talked about on the podcast. And I thought of one. Hey, do you know what it is? What have we four got in common? So I am now going to include myself in this
extraordinary good looks.
Well, apart from that,
I don't know. Yeah, I'm blinded by that.
Well, I'm a teacher too. Oh, I have a kind of long established teaching pedigree. So my teaching background is in further and higher education, but not in the world of IP, of course. It's in the world of kind of teacher professional development and education and those kind of things. So I was just going to ask. My closing question was going to be: you've got the next Gwilym Roberts coming to QMUL. We're going to answer this question as well. You've got the next Gwilym Roberts. Never done any teaching before, right? But you want him to do a bit of teaching for you. What's your number one tip to immediately make him a gold star teacher for your students? So any future potential teacher, what's your tip?
Not just me, because I'm already here.
Yeah, but no, a future you, I said. It wasn't you.
Well, obviously, wear a green, shiny jacket.
For the viewers, we're wearing green, shiny jackets.
Listen, I think the important thing is, in any teaching, at any level, is to how to break things down into digestible components. So you don't just throw information at people. you kind of build it up. So you build up the base of knowledge, so that people actually feel confident. And then when you then have discussions with your students, they feel confident to talk about it because they have that solid knowledge base. So that would be my takeaway.
So I get from that the smallest possible chunk you can give to someone, they can internalise and take it back. Yeah. No, what about you, sir? What's your big teaching tip?
So first, subscribing to what Duncan said, but I think, or in addition, it's maintaining this. You're there for an hour and a half. This relationship with it's. I know it sounds pompous. It's not an audience, but in a way it is. And this is why Zoom is so frustrating. When you look at people and they sit in the class, and you can see immediately whether you're pitching your shtick at the right level. If there's sometimes you look at the eyes and there's nobody at home. And then you adjust. So it's an ongoing thing. Well, here you go.
Yeah, there's no one at home.
It's an ongoing thing, and I think also it's really useful to, especially when you get questions, to be fairly relaxed if you don't got the answer, and it's absolutely fine to say, "Good question. I'll think about it. I'll come back to you next week," rather than just
So that was probably the most useful tip I learned very early on when I was a teacher, and that was that you don't have to be the eternal expert. It's not your job.
Did you hear that, Gwilym?
No, I'm not. What? Sorry, I was on Zoom. Sorry.
So go on, come on, novice teacher.
Well, I've got a good one or a silly one.
I'll do both.
Okay, the good one, not a good one, the sensible one, may not be good, is actually to follow on from that kind of plea to the patent profession coming through, is that I think we're such perfectionists that we're really, really worried about going out in case we get caught out. It's a riff on what Noam just said. Yeah. Please start, qualify, get a year or two under your belt max, frankly, before you go out and start passing on your knowledge to other people. You've got so much to teach. And if they know more than you, learn. It's awesome. And my silly one is always finish with a poem. And I finished the cheese grater lecture with a poem.
Oh, go on. Is this going to grate?
There you go. That's it. He's good. It's one of the rhymes. It's a foodstuff grater with a rotor actuator and a rotor and a stator, so you never need a waiter. There you go. See?
Oh, so I now know your cheese grater was a windy one.
Yeah, see? It rhymes.
Yeah.
I went quiet.
But maybe a final point about education is that I think it's incredible what the trainee patent attorneys achieve. They come to Queen Mary, they usually haven't studied law before in their lives. And it is a certificate in intellectual property law. It's not about drafting skills. Yeah. It's about, probably for the only time in your career, getting that solid foundation in UK and European patent law and other jurisdictions as well. So, the way they're able to adapt, as our head of the university says, the ability to pivot. They can pivot quickly and, take on new academic disciplines. Is just really impressive.
It's amazing. I like completely. Actually, it's such a good point. I found that, to me as a lawyer, it's a humbling experience when you see someone who did not deal with the law coming and to your institution within 3 months. For example, the area which I used to teach, trademarks, they would get themselves to a level of an LLM student. Now, an LLM student is someone who did the undergrad fully in law and then a full year on an LLM. Within some of them, at least, within 3 months of intensive trademark. So it's because if I try the same trick with science, so if we reverse the table, that's not going to look pretty, right? So it's a humbling experience.
I got off lightly, didn't I? Because you didn't ask me what mine was, because you've forgotten I'm a teacher.
I thought you did. I thought you gave it.
No, you didn't ask me, mate. I'm just gutted.
Lee, as a highly respected pedagogue, what's your tip?
Oh, can I do the pedagogy-andragogy argument, or are we not up for that yet?
I was an andragogue.
Okay, well, you think about the root cause of all of this. So my tip would be, I think yours were all brilliant, but one of the things that I've appreciated being in this room with the three of you, right, is we're getting ready to set up the Seeper Hall to do the kind of like the UPC thing, Duncan and Noam. And Charlotte, remember this. Charlotte's in the room with us, everybody. Hi, Charlotte. I was saying to her about the kind of the acoustics and stuff like that, because if I've got one tip, it's learn to use your voice. And the one thing that all of you do when you talk is you look up, you kind of speak high, your voice carries. Doesn't mean you necessarily raise your voice or anything like that. You talk at a relatively normal level, but you can be heard. So the one tip I would give any teacher is just learn to use your voice, because it's the most powerful teaching tool you've got.
Does that apply both for pedagogy, that is to say the teaching of children,
He's Googled
and andragogy, the facilitation of learning for adults, Lee?
Yeah, no, I would argue that the two are largely the same and you should focus on pedagogy, but that's a very old, dated argument. Duncan, Noam, this is where we normally end up with our podcast. Thank you both so much for joining us today. It's been a total pleasure. We're in a pub, so you don't need to run away. This isn't Zoom. You don't just switch off and disappear. You can have another beer and stuff like that.
Yeah.
It's been a real pleasure having you on, and we will have you back because it's been great. Thank you very much.
Thank you.
Next time.
Yeah.